This is a Law for Community Workers podcast. Legal Aid New South Wales acknowledges that all our podcasts are recorded on Aboriginal lands across New South Wales. We pay our respects to all traditional owners and custodians of those lands and extend that respect to elders past and present, as well as to any Aboriginal and Torres Strait Islander listeners joining us today. Always was, always will be. Welcome to episode 2 of our new series, Till the Violence Ends, a series for community and support workers to gain insight from experts found in domestic, family and sexual violence services. This second episode is about domestic violence and tenancy. Lehana from the Tenants Union of New South Wales provides answers to questions such as, how can you leave a tenancy if you're experiencing domestic violence? What are your rights and what do you need to do to leave or to have a perpetrator of domestic violence excluded? The information provided in this episode is correct at the time of recording and should be regarded as information only and not legal advice. Please see our show notes for a breakdown of the episode along with information and links to resources mentioned in today's episode. Lehana, welcome to our new podcast series about domestic, family and sexual violence. Would you please let our audience know about the Tenants Union of New South Wales, where you work and what your role is there?
Thanks, Bridget. My role is as the solicitor Aboriginal Support at the Tenants Union. So I work in the legal team of the Tenants Union, which is a community legal centre that specialises in New South Wales residential tenancy law. The Tenants Union is the main resourcing body for the tenants' advice and advocacy services across the state, and we work to promote the interests of tenants across New South Wales through advocacy, campaigning and law reform.
Thank you. So today we invited you to speak with us to learn a bit about what the tenancy law says if someone is experiencing domestic, family and sexual violence and how they might be able to leave a tenancy and what their options are. If somebody wants to end a tenancy because they are in that situation, what can they do?
Yeah, so there are many different ways to leave a tenancy, but in 2019, reforms were introduced to the Residential Tenancies Act, which introduced a new way of terminating a tenancy called a domestic violence termination notice. And what that means is that by giving this notice in writing to any co-tenants and to your landlord, you can immediately terminate your tenancy without giving a notice period or serving a notice period. And so what the process of the domestic violence termination notice involves is giving the notice, specifying the date on which you would like the tenancy to end, and also attaching a type of evidence to the notice. The evidence only has to be attached to the copy of the notice that you give to the landlord or agent and not to your other co-tenants.
Okay, thank you. Would you mind outlining the sorts of evidence that would be acceptable when you serve one of these notices?
Yeah, so there's 4 types of evidence and you only need to attach one of these types. So one is a certificate of conviction, of criminal conviction for the domestic violence offence that has to have arisen during the current tenancy agreement. The second type of evidence is a domestic violence order, and it has to be one that is in force.
Can I ask you there, when you say domestic violence order, what kind of orders are they?
So, domestic violence order, there's 2 types of what we call apprehended violence orders that you can get against an offender. There's an apprehended personal violence order and an apprehended domestic violence order. So, an apprehended personal violence order, those are the ones made between individuals who are not in a domestic relationship. That might be like co-workers, for example. But what I'm talking about in this context of the evidence types is an apprehended domestic violence order, which is an order that protects individuals in a domestic relationship.
Thank you. And I think there's 2 other types of evidence that you could attach to one of these orders.
Yes, so one is a family law injunction under the Family Law Act relating to that has been made, sorry, as a result of family violence. Again, that has to be an injunction that is in force at the time that you give the notice of termination. And finally, one of the most commonly used types of evidence is a declaration of competent persons. It's a way to provide the evidence required for a domestic violence termination notice that does not require persons to speak to or engage with the legal system at all. And so, what they are able to do is to go to a specific type of professional that, it could be, for example, a doctor, a health professional such as a nurse, a pharmacist, a psychologist. You could also go to a social worker who is a member of the Australian Association of Social Workers, an employee of a New South Wales government agency that works in child protection, or employees of non-government agencies that receive government funding to provide services relating to domestic violence, sexual assault, or refuge or emergency accommodation. And also an approved counsellor is a competent person. And so what you would do if you wanted that type of evidence is you would go to that professional and consult with them and ask them to fill out the declaration by a competent person form. And they would sign that, and you would attach that to the termination notice.
Okay, but you only have to serve that evidence on the landlord, not on any other co-tenants. Is that right?
Correct. So tenants do not have to attach any of that evidence to a termination notice that they give to any other co-tenants, but they do have to give a copy of the termination notice to the co-tenants.
Okay, thank you. What if the person who is a victim of domestic and family violence doesn't want to leave? Are they able to follow a process to evict the person who is the perpetrator of violence?
There are a couple of ways that somebody can stay in their tenancy and try to end the tenancy of the perpetrator. One way is to get a final apprehended domestic violence order, and that final order has to have what's called an exclusion order in it, meaning that there's actually an order excluding the perpetrator from attending the premises of the tenancy. And if you have that final AVO, that automatically ends the tenancy of the perpetrator if they had a tenancy with you. The other way that you can end the tenancy of a perpetrator while staying in the property is by applying to the New South Wales Civil and Administrative Tribunal, or NCAT, we call it, which is it's sort of like a court. It's meant to be less formal, and it's where many tenancy disputes are resolved in New South Wales. And you can make an application ending the co-tenants agreement in the special circumstances of the case.
Okay, and presumably those situations you've just outlined only apply if you're named on the lease that you have.
Yeah, that's right.
Thank you. Lehana, what happens if you experience domestic family and sexual violence and you're a subtenant?
So, really, the answer to that question depends on whether or not you have a written agreement to live in the property or not as a subtenant. And that's because if you have a written agreement as a subtenant, then you are covered by the Residential Tenancies Act. And then all of the rules that would apply to tenants around domestic violence termination notices, for example, would also apply to you as a subtenant. But if you are a subtenant and you do not have a written agreement to live in the property, then the Act does not apply to you, the Residential Tenancies Act. And so in that scenario, I would recommend getting advice, but also obviously to leave any unsafe situation. It's a really good idea, even if you're not covered by the Act, to make it clear in writing to the person that you are renting from why you are leaving, and so that there is a written record of the reason that you're ending your agreement with them.
Okay, so that would help prevent you from being liable for any potential ongoing rent if you've made it clear that that's the reason that you're leaving.
It would, and it would also be a good idea in this situation to get legal advice, just because your legal status really depends on the specific circumstances of your situation. If you don't have a written agreement that you can point to, it really can be quite unclear sometimes in terms of what your rights and obligations are. So it's a good idea to get advice.
Okay, so what about if you fall into a different category, such as if you were a lodger or a guest, and you need to leave because you're experiencing domestic, family, or sexual violence?
So if you're a boarder or lodger, you might be covered under the Boarding Houses Act. It really depends on what your specific circumstances are. And the reason I say that is because sometimes you have a boarding or lodging situation that looks very much like a tenancy agreement and could be a tenancy agreement. So if you are unsure about the type of agreement you have and whether or not it's a tenancy, I would encourage anyone in that situation to get advice, legal advice, to look at the specific circumstances of the case, of what was agreed to. Things like, is rent being paid? Who else is living in the house? All of those factors can determine whether something looks more like a tenancy or more like a boarding house. But in either case, if you are in a circumstance of a domestic violence, while the Boarding Houses Act doesn't have similar provisions to the Residential Tenancies Act when it comes to ending a tenancy for domestic violence, if you were in an unsafe situation, you should still prioritise your safety, exit and let the tenancy or exit the arrangement, I should say, and just make it known to the person who you're renting from or who is in charge of the agreement or providing the agreement that you are exiting for this reason, for the reason of domestic violence, and give that notice to them in writing.
Are there ever costs that you would need to pay if you were on the lease and you give this notice about leaving the tenancy because of you're experiencing violence? Are there any fees that you might be liable for?
If you are exiting using a domestic violence termination notice, your rent liability should stop on the date that you give that valid notice. You shouldn't have to pay any rent after you've moved out and you've given vacant possession and given the keys back. So in that sense, rent should stop. In terms of other types of fees, like for example, property damage costs that might occur during the commission of a domestic violence offence, there is actually a specific protection in the legislation that says that people who have been involved in a domestic violence incident where damage has occurred are not responsible for the costs of that damage. So if, for example, a landlord tries to claim some part of a bond or take somebody to NCAP for damage relating to the property, and that damage happened during the commission of a domestic violence offence, the person who is the victim survivor in that scenario is not legally responsible for that damage.
Okay, that's great information to have because I'm sure that there is often damage that happens during a domestic violence offence, and people may not be aware that if they're the victim, that they would not be liable for that. What about a break lease fee? Would you be liable for that if you're serving one of these notices?
No, if you've served the domestic violence termination notice and attached the required type of evidence, you are not liable to pay a break fee.
Lehana, what can you do about reclaiming goods that have been left behind when you've left a tenancy because you've been experiencing domestic, family, or sexual violence?
So you do have rights in relation to the goods that you have left behind at any house that you've left after a tenancy, and that is because the landlord and agent have responsibilities to give you notice before they dispose of any goods that you've left. The notice that they have to give you really depends on the value of the goods. So, for example, if some of the goods in the house are valued at less than $1,000, then the landlord has to give you 14 days notice verbally before being able to dispose of the goods in an appropriate manner. If the goods are between $1,000 and $20,000, then they have to give you 28 days notice in writing. And then the way that they dispose of those goods has to be by public auction or private sale. If the value of the goods is more than $20,000, then they can only dispose of those goods in accordance with orders from the tribunal. But it's always a good idea as a first step to try to negotiate a time with the landlord or agent to collect the goods from them, and to do that in writing so there's a record of it. And then if they don't cooperate with you, you are able to make an application to the New South Wales Civil and Administrative Tribunal for an order that your goods are returned, or for compensation for any goods that have not been dealt with properly in accordance with the Uncollected Goods Act by the landlord.
Thank you. What about the bond? You spoke about, potentially a landlord trying to claim the bond or part of the bond because of damage that's happened. If you end a tenancy because you need to leave in this circumstance, should you be able to claim your bond back?
So, unfortunately, with bond claims in domestic violence circumstances, it can be very difficult for tenants who are victim survivors to get bonds back from co-tenants who are perpetrators. And that's because the current process under the Act is that if you are exiting a co-tenancy, the first step to try to get your bond back is to write to the remaining co-tenant to request that the bond, or your share of the bond, gets paid back to you within 14 days of the written request. And if that isn't done, then the next step is to make an application to the tribunal for an order that your bond is paid back. So that can be difficult to actually enforce in practice.
Yes, and also you can imagine that if you're in that circumstance, you may not have the clear presence of mind to think about all these processes, because you're just trying to ensure your safety and perhaps your children's safety and the safety of any pets. So
Exactly.
yeah,
And you
it's
wouldn't want to really maybe speak to the person who you're meant to be claiming your bond back from.
Lehana, what about locks? If you're in the situation where you are able to exclude a co-tenant because you're able to get a final apprehended domestic violence order, are you able to get a landlord's permission to change the locks so that they can't return to the property?
Yeah, so as a victim survivor, the law allows you to change the locks if the offender's tenancy was terminated or they were excluded from your home by a domestic violence order. So the Act allows anyone to change locks in an emergency. For example, if somebody has threatened to hurt you or your child. And there's also government programs available to get assistance to change the locks or to improve the security of your home in circumstances of domestic violence. There's the Staying Home Leaving Violence program, for example. But one thing to just remember when thinking about changing the locks is whether or not the person who you are in a co-tenancy with, who might be the offender, is still a tenant, or whether their tenancy has ended or not, because they might still have a right to live in the property and be locked out. And so that's something that it would be a good idea to get advice about. You can still change the locks if it's an emergency, but to any implications of that, if the person is still a tenant, it would be good to get advice from a tenant service about that.
Yes, and I think in all these circumstances that we're discussing, that would be important for people to get advice from their local tenancy advice service, just to make sure that they understand the process and know what they need to do in terms of what the Residential Tenancies Act says. What about pets? Is there anything people can do if they want to take their pets with them?
So there are support services available to maybe get help with pets in situations of domestic violence. There is, for example, a program called Pause and Recover, which supports the care of pets during a health crisis or during difficult times. And the RSPCA also has a community domestic violence program that you can contact by phone.
And what about if you have been included on a tenancy database because of property damage that might have happened during a tenancy where you are living with a perpetrator of violence and you're the victim of that violence? Is there anything you can do to remove your name from a tenancy database? Because obviously that would create problems for you trying to enter into another tenancy.
Yeah. Well, the landlord cannot list tenants who ended a lease by giving a domestic violence termination notice on a tenant database. They're not allowed to do that. And the landlord also can't disclose the information that you provided in the domestic violence termination to anyone else. It's confidential. And so really, if you feel like you've been listed on a tenancy database and you shouldn't have been, then you can make an application to NCAT to have the listing removed because it is unjust in the circumstances. And so you might even be in a situation where you've ended the tenancy because of domestic violence but haven't used a domestic violence termination notice. So currently, there is no explicit protection against database listings unless you have issued the domestic violence termination notice. So if you're in that scenario, you have left because of domestic violence, but you used another way of terminating the tenancy and not the domestic violence termination notice, you can still apply to NCAT to have the listing removed because it's unjust in the circumstances and because it's causing you disadvantage.
Are there any different rules that might apply for a tenant who is living in social housing, so public housing or community housing? Is there any change in the things that they would need to do if they need to leave because they're experiencing domestic, family, or sexual violence?
The short answer is no. The domestic violence provisions relating to termination notices, they still apply to social housing tenants and landlords. So you can still give a domestic violence termination notice in the same way as you would in a private tenancy in a social housing tenancy. I guess one of the things that is different for social housing tenants in terms of what I've mentioned so far is the exemption from listing on a tenancy database. And that's because many social housing landlords don't use those tenancy databases. They have their own databases, their own classification lists and waiting lists. And so the protection against listing on a database doesn't apply in the same way. But all of the other protections in relation to domestic violence related damage and protection from liability for that, domestic violence termination notices, they all still apply to social housing tenants.
Thank you. What about if you are a social housing tenant and you receive an adverse listing as a consequence of living in a situation involving domestic, family, or sexual violence? Is there anything you can do to ask the social housing provider to remove your name from an adverse listing?
Yeah, so social housing providers have discretion about issues like and decisions that they make, such as your classification as a former tenant and whether or not you're eligible for the social housing waitlist. And so it would be a good idea to get advice if you find that you have somehow been made ineligible for a social housing waitlist or received an adverse classification as a former tenant of social housing that's preventing you from going on the waitlist. And so it's a good idea to get advice as a first step on how to deal with that, and also to communicate with the social housing landlord in writing that the reasons that, for example, the damage that might have occurred during a commission of a domestic violence offence. So explaining why some of those things that might have arisen that have led to the wrongful classification of you on the wait list. Just explaining those things in writing is another good idea, so that the housing provider can exercise their discretion to adjust your status on the wait list.
I imagine too that there would be an appeal process against that sort of classification if the housing provider chooses not to exercise their discretion in your favour.
Definitely. So if you are unhappy with any decision really that the social housing provider has made in relation to your classification, your eligibility for social housing, you can firstly appeal internally to that provider. And the next step after that would be making an appeal application to the Housing Appeals Committee, which is an independent body that reviews the decisions of public and community housing landlords.
Do you have any advice or suggestions for community or support workers, or indeed domestic violence specialist workers who might be supporting women to leave a tenancy, or who may have just left a tenancy? Do you have any tips for those workers about what they could do to support those clients they're working with?
Yeah, definitely. So I think if you are a support worker, it is possible that you fit within one of the categories of a competent person. So if it is a competent person declaration is needed by your client, and they really have no other way of getting any of the other types of legal evidence, you can complete the form, the competent person's declaration form, for them. That's one way to provide support. I think another way to provide support would be just referrals to other services like counselling services, tenants advice and advocacy services, the pet services if needed. Just being aware of what is out there, and we do have on our fact sheets quite a number of different places or referral places that might be useful for somebody who is experiencing domestic violence and needs assistance with housing. And so just being aware of those services and knowing where might be helpful to refer your client. And also just it could be helpful to sit with your client if they're comfortable and enough to go through a chronology of what happened in the domestic violence incident or circumstances, so that there's a written record of what they've experienced, that they don't need to keep telling other support workers every time it happens and sort of be re-traumatized, that there might be a chronology that they can point to each service that they go to. So helping them with that could also be helpful.
Uh, Thank you, Lehana. You mentioned the Tenants Union fact sheets, and I know how wonderful they are. They're available on your website. Would you please let our audience know the website address where people can find that information?
Yeah, of course. So our website is tenants.org.au, tenants.org.au. We have a fact sheet on domestic violence. It's our fact sheet 12, but also a supplementary guide, which provides additional information on things like the domestic violence termination notices, declarations by competent persons, and also other options available to victim survivors under tenancy law. And it also summarises the legal options for co-tenants, subtenants, and head tenants. So for different types of legal arrangements.
That's great, because it's not always easy to remember the detail, so being able to refer to the fact sheet is good. And for workers who might want to refer their client for legal advice, would it be correct to say that most tenancy advice and advocacy services, with a client's permission, would be happy to have a support worker join in an appointment where they're advising the client in that situation?
Yeah, I definitely think that most services would be happy to have a support person present as long as they had consent from the tenant to discuss the matter with the support worker present. Uh, that's something that happens commonly.
And Lahana, if a support worker is trying to find out where the closest tenancy advice and advocacy service is, they can find that information on the Tenants Union website, can't they?
They can, just by going to tenants.org.au. There's a get advice button, and just if you put the tenant's postcode into that, their local service, and the contact details will come up.
That's great. And I'll just let our audience know that we will include in the show notes for this episode links to the website and the fact sheets that you've mentioned. Lehana, is there anything else that you would like to add on this topic?
The law is adapting and evolving to better meet the needs of people who are experiencing domestic violence with their housing. One of the things that it's good to know is that those changes that were introduced in terms of the domestic violence termination notice, the protections against liability for damage that occurred during a domestic violence incident, those are all being reviewed. And recently there was a roundtable discussion to progress that review, and they are looking at some key changes to improve these laws. So things like expanding the list of competent persons further, broadening protections against liability for all renters experiencing domestic violence, and perhaps most significantly, tackling some of those challenges relating to bonds for renters living in circumstances of domestic violence, where I mentioned it's not a very, the process currently doesn't have a lot of utility. So trying to improve the laws. And so hopefully we see more of that change happening in the next couple of years.
Thanks so much for giving me your time and recording this episode with us. We really appreciate it.
Anytime.
That was our guest, Lehana De Silva from the Tenants Union of New South Wales. This has been episode 2 of Till the Violence Ends. If you or someone you know is being impacted by domestic, family or sexual violence, please call the DV hotline on 1800 65 64 63 or 1800 RESPECT. That's 1800 73 7732, or the men's line on 1300 78 9978. If you're in an emergency situation, please always call 000. Thank you for listening.